Everyone, welcome to today's IP speaker series brought to you by Accelerate IP. My name is Bradley. I'm the Education Program Manager at New Ventures BC, and I'd like to introduce you to Byron Thom and Mitchel Fleming. Today, we'll be talking about culture and law, and again, this is available as part of our IP speaker series. If you are watching this after the date, thanks for checking out our YouTube channel, and for those in the room, we'll be uploading this there in the coming week as well. I'll let Byron introduce himself, and then we'll get right along. Byron, I'll hand it over to you.
Great, thank you, Bradley. And thank you to Accelerate IP and New Ventures BC for hosting this fireside chat and this IP speaker series. I think this is a number in what will be about 10 different webinars on different aspects of intellectual property law, covering a wide range of concepts and educational aspects that may be of interest to our client audience. Today's session is on traditional knowledge and traditional cultural expression. It's a topic that may be a bit new to a number of members at Accelerate IP, but we have kind of an engaging speaker and a really interesting conversation lined up for you to talk about how these things apply across Canada and around the world. And maybe provide some practical insights to those folks who are dealing with these issues and things to think about, right, as they go about building out their businesses and their entrepreneurial journey. Just to start, maybe I'll introduce myself. My name is Byron Thom. I am a partner at BDC Capital within what's called the Industrial Innovation Venture Fund. Very briefly, my fund invests in early stage startups, Series A, Series B, across the industrial innovation space. Right, broadly, industrial innovation we think of as three main pillars. So one is advanced manufacturing, so robotics, analytics, and AI. Two is ag tech and food tech. And three is any kind of technology for the extractive space, typically efficiency related or productivity related or sustainability related to mining, oil and gas, forestry, and oceans. Before I begin welcoming our guest speaker, and further diving into the topic, I'd like to do a brief land acknowledgement, recognizing that I myself am based in Vancouver on the traditional and ancestral territories of the Coast Salish peoples, including the Musqueam, Squamish, and Tsleil-Waututh. And I know we have many members joining from across BC, and Mitchel himself is joining from Ontario. And so we'd like to just quickly acknowledge and thank, right, the traditional caretakers and owners of the land in which we currently live, reside, work, and play. Right, I think Canada is a mosaic of many different cultures, and we're very blessed to be living in this very bountiful country, and so we're very thankful to the traditional owners and caretakers of these lands. As mentioned, the topic today is on the intersection of IP and traditional knowledge and traditional cultural expression. This is a little bit different than many of the other webinar series in that it's not meant to be a prescriptive discussion in terms of what you should do and what you shouldn't do, but it's really meant to start as a starting point for a discussion, right? To start you thinking about these issues and bring awareness to some aspects of IP or IP adjacent topics that many folks really haven't spent a lot of time thinking about. And so with that, I'd like to introduce Mitchel Fleming. And instead of introducing him myself, I'll let him kind of start there himself. And so Mitchel, please, welcome to this webinar series. And we'd love to kind of hear a little bit about your background and your perspective.
Thank you, Byron and Bradley. Thank you for starting off the introductions. So my name is Mitchel Fleming. I'm of mixed Indigenous and settler heritage. I was born in Halifax, or rather, I say Halifax because most people don't know where Fletcher's Lake is, Nova Scotia, but I was ostensibly born in Halifax, Nova Scotia. I did a music degree in Newfoundland at the Memorial University of Music, and then I pursued a law degree at McGill in Montreal. I currently practice media and entertainment law. The majority of my clients are based in Toronto. I myself am currently residing in Ottawa because my fiance ended up taking a job with the federal government, but I do serve as clients across the country. I do work regularly with Indigenous filmmakers, Indigenous journalists. It's a point of pride for me to work with Indigenous creators. And as a result of working with Indigenous creators, I myself have had an opportunity to engage with professionally traditional knowledge and traditional cultural expression. And for me as a lawyer, it's always interesting to deal with these things because they don't fit within the colonial IP structure. So finding creative, respectful, and constructive ways to engage with traditional knowledge and traditional cultural expression is really important for me and for anyone that is working in this space. And when I'm not working with traditional cultural expression and traditional knowledge, I'm helping people make movies. So I hope that that's sufficiently comprehensive, Byron.
Awesome. And thank you for that. And we may dig into some of your professional work as well, right, there's obviously so much in the arts that deal with this that I'm sure it'll be woven into the conversation this afternoon.
Absolutely.
Just a reminder, as Bradley mentioned, this webinar will be posted to YouTube. And we also have a chat feature as part of the webinar. And so as we progress through the conversation and there are particular questions that the audience may have, please feel free to add questions to the chat, and to the best of their ability, we'll either try to weave them into the conversation or may get to them at the end. If the questions are, if we are unable to get to the questions, there may be an opportunity for you to reach out directly to myself or to Mitchell, and hopefully we'll be able to address them in one way or another.
And I should also throw out there the perennial disclaimer that anything I say, is not legal advice. If you do need specific legal assistance on any matter, please do feel free to reach out to me. I'm pretty responsive. I'm sure, Bradley, would you mind throwing my email up in the chat just so if anyone needs to contact me, they can contact me?
Sure thing.
Perfect. And so maybe to start off the discussion, it would be helpful to kind of create a dictionary for our audience on what we mean by traditional knowledge and traditional cultural expression. I think as we discussed at the beginning or the outset of planning this agenda, I think that's probably a first place to start. And then after that, maybe I'll give a quick explanation of kind of more standard black letter IP concepts that we'll want to kind of compare and contrast.
Yeah, certainly. So I guess the best place to start when defining something would be in an official document. So I helped author this report on traditional knowledge and traditional cultural expression a number of years ago. So I figured that was a good place to get my definition. Traditional knowledge, generally understood, is a living body of knowledge passed on from generation to generation within a community. And when we're talking about traditional knowledge and we're talking about traditional cultural expression, in this context, we really are speaking to the Canadian Indigenous experience. However, communities around the world possess their own unique traditional knowledge and traditional cultural expression. But for the purposes of this talk, I'll limit it. Well, for the purposes of this part of the talk, I'll limit it to the Canadian Indigenous experience. So traditional knowledge is the knowledge itself that is passed on from generation to generation within a community. Traditional cultural expression is used to explain the forms in which traditional culture and traditional knowledge is represented. And this may include songs, music, dance, art, designs, names, signs, symbols, performances, handicrafts, narratives, and other types of artistic and cultural expression. So similar to what we might find, and I'm sure Byron will get into, in copyright law, you have the traditional knowledge, which is these ideas, which is this knowledge base, and then you have the cultural expression, which is the manifestation of that traditional knowledge. So I hope that those definitions are helpful for the audience.
Yeah, maybe let's just talk a little bit about particular examples that may be helpful for our audience to kind of help situate them. Right? Maybe what is kind of an easy example for people to understand from a knowledge perspective that then turns into an expression.
Certainly. So a knowledge, okay, so like an example of traditional knowledge might be, and this is an East Coast example, the use of Labrador tea for diuretic purposes, right? Like Labrador tea is it's this low brush that grows, and you can use it as a, as a medicinal herb. You can brew it into a tea. It looks like a pine needle, but traditional knowledge might say that if you take too much of it, you can use it for diuretic purposes. So that's an example of like community specific, regional specific knowledge that will be passed down between members of a community and might not otherwise be known outside of that community. Another example, to take something from abroad, is and I forget the scientific term, but the stevia leaf, right? The stevia, like stevia is a plant, or rather stevia is extracted from a plant. And there was a group down in where I'm trying to remember the indigenous group in South America, but I'm forgetting the name now, unfortunately. There was a group in South America that knew about the stevia leaf, that used it for traditional practices, ceremony, but when it got out that stevia leaf has this very sweet flavor, and that knowledge was spread out into the exterior community, that traditional knowledge was then used by Coca-Cola and Pepsi and other soft drink companies to sweeten their drinks without adding calories. So you can see here how traditional knowledge can actually then be leveraged by third parties or the community itself. In this case, it was third parties, to reap some sort of economic benefit. And then an example of a traditional cultural expression, using an example from the West Coast, and this is something that I'm not as familiar with, is certainly totem poles. It is an expression of cultural knowledge. It is an expression of cultural identity. I don't profess to know anything more than that, as it's a culture with them, which I'm not as familiar, but that is an example of how traditional knowledge can be expressed in some physical, artistic, creative, and spiritual form.
Okay, perfect. Yeah, thank you for that. That's very helpful. And maybe even just coming back to your traditional knowledge with regard to tea, maybe, and I'm not sure in that culture if there's a tea ceremony or any type of sharing of teas that could become a cultural expression as well.
Yeah, exactly. And it's not something that I know a lot about. I learned about it more in studying some international protocols, but it is you're entirely right. It's really difficult to separate the traditional knowledge itself from the traditional cultural expression, that cultural practice, right? Because the two are so closely integrated that oftentimes to take the traditional knowledge out of the cultural expression is actually to use the knowledge in a way that might be antithetical to the expression, the original expression. So, and that's something I'm sure we'll get into later in our discussion.
And just before we get into kind of black letter IP, maybe just talk a little bit about how traditional knowledge and traditional cultural expression is shared amongst kind of Indigenous cultures across Canada. Oftentimes we talk about fixation, but even those concepts are maybe a little bit different within the Indigenous community.
Absolutely. Each Indigenous group handles the transfer of traditional knowledge differently. A principal mode amongst that is the tradition of oral traditions, the practice of oral traditions, which is it is the way in it is people from one generation conveying stories, conveying knowledge to the next generation ad infinitum. It goes on forever, which when comparing it to intellectual property, and Byron, I'm sure you'll talk about this, it can pose some interesting challenges because in for example, copyright law, there is this necessity that this information be written down to attract any sort of formal protection. So trying to figure out how oral traditions, non-tangible knowledge, non-tangible, like meant like a written down, is somehow like fits into the Canadian intellectual property regime.
Yeah. And so because of in my understanding, right, as a non-expert in this, is sometimes the cultural expression is how the traditional knowledge gets passed on. Because of, to your comment, the stories and the songs and the artwork that is both a cultural expression, but is imbuing knowledge to future generations or time immemorial.
Yeah, exactly.
Yeah. Yeah, it's very fascinating. And as mentioned, we'll kind of dive into this further, but maybe just quickly to flip it to the other side to talk about some of the IP concepts that some of our audience members will be more familiar with, right? And hopefully even just that brief introduction starts people thinking about how does copyright, how do trademarks, how do patents differ from some of these traditions that our indigenous communities have been using for thousands of years or longer. And so maybe it's helpful to also provide a bit of a dictionary for those terms, and it'll allow us to be able to compare and contrast as we move further into this conversation. And so to start off, maybe I'll just talk briefly about kind of the three types of IP that most people are familiar with. There's obviously other types that could also apply. But from a copyright perspective, particularly when we're talking about cultural expression, seems to be the most obvious, right? Copyright applies to original, literary, dramatic, musical, and artistic works, right? That are in a fixed material form. So that fixation is an important aspect of copyright law, because if we don't fix it, then it's hard for people to know about it, right? Because there's meant to be economic benefits that is part of the bargain of copyright and trademarks and patents. And right, once you have a copyright, the owner has the sole right to produce or reproduce that work or a substantial part of it in any material form, the sole right to perform that work and any substantial part or form in public. And if it's unpublished, the rights to publish it or any substantial part of it. And so it's really talking about economic rights for original literary, dramatic, musical, or other types of creative expressions, right? And there's tests to say whether or not something is original, but for the purposes of this conversation, not really important. It's more that it is kind of fixed work that has a cultural aspect to it. Trademarks, on the other hand, are meant to provide a sign or combination of signs to tell a person that a particular good or service comes from a particular person, right? So it's to distinguish their goods or services from those of others. And really, it's meant to protect the public in one paying for something, but also for talking about quality or not quality. And so to your Coke example, the brand of Coke is a trademark. And when you buy something from Coke or from Apple or from Microsoft, you're expecting a certain quality of or type of product or service. And so trademark is really an intangible asset that companies typically or persons build goodwill towards, right? And then there's value in an intangible asset because it provides a brand for selling particular wares or services. And finally, where I actually spend most of my time, at least when I was a practicing lawyer, is in patents, right? And this is very well known to our audience who is really using Accelerate IP as a way of, one, educating themselves on the patent process and intellectual property generally, but patents is a huge part of Accelerate IP. And as we know, patents cover new and useful inventions, right? So a product, composition, machine, or process, or any new useful improvement to an existing invention. And the common test for patentability is whether the invention is new, useful, and non-obvious in a patentable subject matter, right? And there's a number of exclusions of subject matter that are not patent protected. And really the bargain of patents is in exchange for explaining how your patent works, you get a time-limited monopoly on that invention, and to allow you to monetize and get economic benefit from it, from all of the hard work that you put into inventing, right? Whatever you've invented. And so I think when you think across the main types of IP, they're really a tool for helping rights holders to get economic benefits from whatever they're trying to protect. These are all intangible, so they're not products necessarily. And it's a way to encourage the development of art, of brands, and of inventions. And so I think just kind of explaining that and hearing this myself, there seems to be a lot of incongruencies, and I know that's really where we're going to spend a lot of time diving into with Mitchell's definitions and generally accepted definitions of traditional knowledge and traditional cultural expression. And so why don't we kind of dive into that? And so maybe Mitchell, like what are some of those friction points? And I think as we kind of explore these friction points, really the purpose is to, one, understand them, but really also say, okay, well, why is this important? And I think if we can have that as a takeaway of this conversation, I think it'll just help frame the conversation as we go through it.
Certainly. So there are some friction points that are a little bit more obvious, like the geographical boundaries of intellectual property law. So, as many of you might know, IP law is national in its nature. So you have Canadian patents, you have US patents, you have EU patents, etc. But traditional knowledge is not necessarily tied to a specific geographic region. You might have communities that span across countries, so accommodating and accounting for the transnational nature of Indigenous communities doesn't really sit well with the national nature of intellectual property law. But others are a little bit less obvious. So, for example, like we all know that patents can be owned by companies, but patents can be owned by individuals. Well, similarly, traditional knowledge and traditional cultural expression, it can be held by communities, right? The communities are the owner, for lack of a better word, because ownership doesn't necessarily have the same meaning to all Indigenous communities. Like certain things can be held almost not in trust. Again, here I am trying to explain like the manner in which communities engage with traditional knowledge and traditional cultural expression through a Western legal lens, right? Like you can see even there's a bit of a conflict because I'm having to try to draw parallels where a parallel might not always be appropriate. The point that I'm trying to make is that traditional knowledge and traditional cultural expression can be held by communities, right? So trying to figure out who is the proper rights holder isn't as straightforward as going to the patent registry and seeing that X company or X individual owns the thing. It sometimes requires more of a conversation and more of a consultation with the community to figure out how one might go about not just legally, but ethically engaging with this traditional knowledge and traditional cultural expression. I think that where we're going to run into a lot of issues and where we might see this broad overarching friction is that when myself as legal practitioners, but you as inventors and business people are seeking to engage with traditional knowledge and cultural expression, you may find yourself operating in this pseudo-legal realm where the sorts of considerations that you're looking to make aren't necessarily legal ones, but they're more ethical considerations. They're more respect and like consideration driven consideration, but because what you're doing is you're not always dealing with something that is going to fall under formal IP protection, but you might be dealing with something that would nevertheless have non-legal ethical repercussions were you to deal with them, especially in like in an inappropriate manner. Do you want me to continue talking about some of the friction points, or do you want to
maybe let's just stop there for a second and let's explore this a little bit.
Mm-hmm.
And so I think one of the things that came out of that is talking about across boundaries and collective ownership and kind of we think about IP has similar geographical issues and cross-boundary issues, and there's been harmonization of kind of intellectual property regimes because we know it's important for business. And so are there any parallels to that within the international community with regards to cultural expression and knowledge? Like, what does UNDRIP have to say about these two concepts? Or yeah, like let's start there. Or like, is there a larger grouping that of elders or of indigenous rights holders who are trying to solve some of these problems on either geographical boundaries or collective ownership issues?
I think that's a really good question to ask. You know, you have unfortunately caught me with a lack of knowledge in this respect, which is fine. I don't know everything, but you know, tools such as UNDRIP seek to give Indigenous groups the ability to pursue self-determination and pursue initiatives that would look to look to preserve this traditional knowledge and traditional cultural expression. Evidently, it's incumbent on each UN member state to take those those treaties and implement them at a national level. But yes, like that is an example of a worldwide initiative to preserve and empower Indigenous communities globally to protect not just protect, but to grow and develop their culture. And then I had spoken briefly about this concept called the Nagoya Protocol. Again, I do not profess to be a individual versed in like bio and plant breeders' rights and stuff like that. But it is, again, another initiative which says, all right, we have these groups which possess traditional knowledge and traditional, the traditional knowledge specifically, but there are groups that have traditional knowledge about how certain plants might be used for commercial purposes. Let's figure out ways for private business and Indigenous groups to come together and formulate some sort of benefit sharing arrangement, right? That's very specifically tied to plants and organisms and how you use them commercially, but it's that sort of thinking that that really pushes the preservation and commercialization of traditional knowledge forward.
Yeah. Okay, let's dive into that a little bit because that's actually super interesting to think about because it goes to your comment around collective ownership. And so maybe actually just quickly before that, maybe quickly explain to this group what UNDRIP is. I apologize for not explaining it and using an acronym that some people may be unfamiliar with. Did you want to just quickly give it?
Certainly, I can't really dig into the substantive, but the UNDRIP is the United Nations Declarations on the Rights of Indigenous Peoples. I wish I could speak more to it. UNDRIP itself doesn't actually play a large role in my practice. So the substantive legal elements I'm less familiar with. So I do apologize for that.
Yeah, but generally it just talks about certain kind of well-known human rights and kind of that peoples across the world have agreed upon with respect to Indigenous practices and cultures that Canada has ratified and BC, where we all live, has not only ratified, it is actually implemented through something called the Declaration Act. And so it is kind of like a founding piece or treaty, or almost the equivalent of a treaty. It's not a treaty, but that Canadians or Canadian governments are starting to implement because we understand that our Indigenous folks are also living across the border in the US, and it's really a collective worldwide issue in order to be able to kind of protect not necessarily traditional knowledge and cultural expression, but rights generally in ways that they haven't necessarily been respected previously or ever.
Absolutely.
Yeah.
Absolutely.
Okay, but coming back to collective ownership and talking about plant breeders' rights. So this is something that I am not an expert in any case, but two things is one around ownership is like, hey, I breed plants, and if I have a particular species or subspecies or particular breed that is quite useful, I can file seeds with the Canadian government, and then the Canadian government will then have those seeds and say, hey, these seeds are your seeds, and no one can use these seeds unless they pay you for it. And so if we come and then juxtapose that with stevia, and I don't know if the stevia plant, is it called a plant or whatever, the stevia, whatever
It's a
organism.
leaf. It's like a leaf. Yeah.
Yeah.
A leaf.
Like whatever grows the stevia leaf, who owns that, right? And the indigenous cultures in South America may be using this for thousands of years. And there's no necessarily one owner, but they may have been breeding this for thousands of years as well and spent a huge amount of time and effort getting the leaf to grow in a way that produces stevia in the way that they want it to grow. And so do you know if they were able, like if they're getting compensated in any way, or if someone just kind of came in and took it in order to be able to benefit economically?
Yeah, the specifics I'm not overly familiar with. I mean, I've heard anecdotes. Again, these are anecdotes. I don't profess to know whether or not they're true or not, but like something along the lines of commercial parties from North America made contact, they found this plant, and then they said, oh, this is phenomenal. They took it back, and then they start growing it, and then they harvested domestically and planted in foreign countries, and then a whole market is built up around this plant, and at least as far as I know, like no real remuneration has made its way back to that first group that said, hey, we have this plant that we use in our traditional medicine, it's also sweet. So like I do not know that any remuneration has made it back. But it poses an interesting challenge, right? Like it is knowledge that is maintained by a group and is used for a very specific reason. And the decision to take that and bring it to the world, it really is it's not really a decision that ethically should be made by the Coca-Cola company. I'm just using them as a placeholder. I'm not ascribing fault to them right now because I'm not sufficiently familiar with the facts. But like the decision to take that traditional knowledge and bring it to the world, really ethically should be a decision made by the group that is currently using it, a group that understands it, and a group that has been growing it for millennia, right? Like, and I think that that's one of these ethical considerations that we need to be considering when we're dealing with indigenous groups is, there might be this knowledge that might not otherwise be protectable or protected because it's been around so long. Another friction point is that, whereas patents last a fixed amount of time, traditional knowledge and cultural expression, they've been existing since time immemorial, right? So any protection that a group might look to be able to obtain over a specific piece of knowledge might not be possible, and it might not be there. So there might not actually be any formal protection stopping any third party from coming in and taking this knowledge. But if you're that third party looking to come into this community and say, I'm going to take your leaf and go someplace else and exploit it, well, I think that you as an ethical actor should really consider, well, like, what are the ramifications of this? Not just legally, but like, are there larger ethical considerations that I should make in my dealings when engaging with traditional knowledge? And I mean, I'm of the opinion that it's a yes. But that's I've opined, but I don't know exactly what happened with the stevia example. I'm sure some digging will elucidate me, but I have yet to do that.
Yeah, no worries at all. But I think just talking about it can just bring up both the legal and ethical issues that I think is important for our audience today just to be asking themselves as they're working with any kind of group, right? And we'll talk about how traditional knowledge and cultural expression is not even necessarily a fully indigenous aspect. It goes across cultures, and lots of other examples that we can talk about. But maybe on the collective ownership side, so you say from a best practice perspective, and we don't know the particular examples, and so we're going to loosely talk about stevia in the South American context, but not knowing the specific details. Like what would be a good approach to if you were wanting to leverage, right, that knowledge and in a product? Like how do you even engage with, right, who is collective ownership? Like are there kind of best practices on how you would start that level of communication?
Certainly. Well, I can speak from my own experience in the film and television industry. There was published a number of years ago I'll just get the name of it here because I have it printed out. It is a production guide for Canadian producers, film and television, when working with First Nations, Métis, and Inuit communities, cultures, concepts, and stories. It's called the On-Screen Protocols and Pathways. A very good read if anyone is interested. And fundamentally, the starting point for all of this is that Indigenous people should be consulted on, compensated, and their consent obtained for the use of their traditional and contemporary knowledge and cultures. And the privacy of sacred, secret, or sensitive knowledge, culture, and objects should be respected. When you're engaging with Indigenous groups, Indigenous societies, like respect is number one. Like really just like you have to go in respecting the fact that there are elements of their culture that are incredibly important. And unless you have the buy-in of, you know, the decision makers, the community, whatever the case might be for a particular Indigenous community, your engagement with that is going to lack the kind of respect that you need to engage with it ethically. There were five, I mean, I'm digging through it now, but there's 4 pillars for engaging with Indigenous communities, at least in the film and television sector. And that's engagement, so establishing a set of values for the project, building respectful relationships, and outlining the intent of the project. So really engaging with the group. Consent and permission, actually obtaining permission from the people who have the authority to let you onto reservation land, for example, let you into the community, let you attend a powwow or a healing circle or any other ceremonial activity. This one is specific to the film and television, but distribution is like when you're distributing the thing. It might be in other contexts, marketing, sales. Appropriate acknowledgements, and contextual marking, and markings on marketing materials, and making sure that some sort of the products and the show can make their way back to the community, right? So they can also benefit from the creation, from the story that you've told. And then also collaboration. Ultimately, you want to be liaising with elders councils, you want to hire a community liaison, and you want to develop those community benefits and capacity agreements that are going to see the community itself, who is the source of this story or this knowledge, benefit for years to come, right? We don't want to, what we're trying to be is we're trying to be collaborative, we're trying to be respectful, and we're trying not to be extractive, right? The people who took stevia and ran, you know, that was extractive, right? Had it been different, had there been a true and honest right sharing and resource sharing agreement put in place all those years ago, it might be a different story today. We might be having a very different conversation about this. But the history of Western nations being extractive, particularly in the context of Indigenous communities, is well known, and it's something that we're looking to remedy going forward. So
yeah, we have a question, and so
4 pillars, I would say.
got it. Yeah,
sorry,
that's very helpful. And maybe while I'm just quickly explaining the next one, if you can actually provide the name of that in the link, so anyone who is interested in downloading that for themselves or referencing at a later time has the ability to find it online if it is available online.
Yeah, certainly. It is available online. Bradley, it's called the On-Screen protocols and pathways. It's easy as that. So
You maybe want to quickly find a link for that, Bradley, and then find that link and stick it in the chat. That'd be super helpful. But maybe just asking a question that Beth in the audience has asked is, from a proactive perspective, why couldn't or wouldn't the First Nations register an industrial design, for example, as a proactive measure? And so asking, right? I mean, I have thoughts on this, but I would love to kind of get your response.
sorry, could you reframe the question? I'm not exactly sure. What are we talking about here?
So, like for the stevia example or anything where they know there's maybe inherent value in the traditional knowledge or expression. Maybe Beth, do you want to ask your question? Yeah.
So, for example, snow goggles are a traditional knowledge way before skiers had goggles. So, and a number of different First Nations communities had their own distinctive designs. So industrial designs. So if I belong to a Dene community where I have a very distinctive design of my goggle, why wouldn't I be proactive and register a industrial design on something that can be very very clearly linked to my community? Same with beading patterns, right? There's very distinctive patterns for different First Nations. It seems to me that because there's economic value and to protect from cultural appropriation, there's an opportunity for First Nations to be proactive and to actually work within the IP law so that they can block against cultural appropriation and potentially reap some economic benefits by licensing their designs.
Okay, I see what you're saying. Just writing down your points. So there is a good question. It really is a good question, because when we were developing this report on traditional knowledge and traditional cultural expression, we did conclude that there were ways to commercialize in traditional knowledge and traditional cultural expression through the Canadian intellectual property regime, right? For dance, songs, written work, obviously copyright is an opportunity, and yours is a phenomenal example of industrial designs and snow goggles. I would highlight a couple of things. Like one, in the stevia example, right? Cat's already out of the bag at that point, right? Someone's come along, someone's taken the knowledge, and someone has already commercialized it. So the opportunity to seek formal protection is gone. And I don't know, with respect to the goggles, right? It might be that someone has already taken that idea and gone off and exploited it themselves. Maybe this non-Dene individual has gone and registered a industrial design before the community was able to, right? So there is this temporal aspect that can be problematic depending on the nature of the invention or the nature of the expression or knowledge. That's the first thing. The second thing is that, as I was speaking about some of the tension, some of the frictions that exist between traditional knowledge, cultural expression, and the formal IP regime, unfortunately, well, I don't say unfortunately. The fact of the matter is that some of these expressions have been around forever, right? So trying to claim copyright on a traditional song might just not be an option, right? Because it's like, oh yeah, we want to get a copyright on this beating pattern that we invented 2,000 years ago, right? It doesn't work within Canada's IP regime. So again, that's a brick wall from a protection standpoint. And then thirdly, and I'm not just trying to throw up I'm not trying to be argumentative. Because I recognize the validity of what you're saying, and I think that there are instances where to mixed degrees of success, we have seen Indigenous art use things such as trademarks, or they're not geographical indicators, but they're marks of a sort, like authenticity marks, to bolster their value in commercial circles. Like, for example, Cape Dorset, right? If you have a Cape Dorset stamp on your carving, boom, like the value is immediately higher, right? And that's a way of funneling like Southern money from the sale of that art up to Cape Dorset, right? So I agree. I think that there are opportunities for Indigenous communities to leverage Canada's IP regime to commercialize their traditional knowledge and traditional cultural expression. What I'm trying to demonstrate is that there are some practical limitations to that. And the last of which is that sometimes a group just does not want to commercialize a specific piece of knowledge or cultural expression, right? Like that, it could just be the case that this specific song, this specific type of carving, this knowledge about stevia, for example, holds a very sacred place in that community, and they don't want to turn it into a product, right? So how do you afford a group that has created this knowledge the right to determine how that knowledge is used, is implemented? It's a really good question. I mean, you could say that technically they're fitting within the trade secrets regime. I don't know, but that's just keeping, that's protecting knowledge, right? So I think that you make a great point. I just think that there are some practical realities to having Indigenous traditional knowledge and cultural expression find their way into formal Canadian IP regimes. So,
Yeah.
but thank you.
I would just add from my perspective, and this is more from a Western Canada perspective, is understanding that that mentality is putting the onus on the cultural owner to kind of adhere to a system, right, that they may not actually agree with, and or have the kind of capabilities, right, economic or otherwise, to be able to navigate. And so this is where it's kind of coming from a appropriation perspective. Well, just because there were ways available to you and you didn't use it, that means that, like, you kind of lose out is the question sometimes, right? And I think society is starting to move away from that, where we talk about appropriation or misappropriation, and this being something that, right, comes back to the ethical considerations that business owners, rightfully, in my opinion, need to be considering. And so maybe let's take an example of this and kind of follow it down the conclusion on how you could, or at least how the media or society has said you could or should have thought about working with different cultural rights holders on bringing something to market. And so the example that Mitchel and I kind of talked about that we maybe want to talk a little bit about, and would love to kind of get anyone else's opinion who's on the call, is the boba tea example that was recently in the news with respect to a Dragon's Den episode. And so it doesn't necessarily come from an Indigenous perspective, but it's a Canadian example of a company in Quebec that went onto Dragon's Den and has built a business selling a type of bubble tea that they market as healthier, using less sugar than traditional bubble tea, or bubble tea that you'll find in stores up and down across Canada.
Apparently they didn't know that you can get like quarter sweet and half sweet, at any good bubble tea shop, but yeah.
And so it became a little bit of a storm on Dragon's Den when they had identified that, right, they had no necessarily tie to something that had been historically associated with the Asian community. And so they were accused of cultural appropriation or misappropriation. And this is, and I'm not picking on these folks, and there are examples up and down, but we thought we could just quickly talk and maybe use this as a best practice example of what they may have wanted to think about when they wanted to start their business, right? And in the society where cultural misappropriation is considered a negative, there are consequences to acting inappropriately. And so as business owners and entrepreneurs, these are just things that you may want to think about, because there can be repercussions to not thinking in a way that is culturally sensitive.
Yeah, I think, Byron, what was, I don't know if it was this year or last year, that the like the Merriam-Webster word of the year was authenticity. Right, like I might be getting the dictionary wrong, I might be getting the year wrong, but I know the word was correct. The word of the year was authenticity, because people really are looking for, individuals who display, an authentic self. I don't know what that means necessarily, but in a commercial sense, right? They're looking for something that is authentically what it is, supposed to or perceived to be. And Byron, you noted something. I think it's important that, at least in circles that I've discussed this with, there is this difference between cultural appropriation and cultural misappropriation, right? Like there's nothing ethically stopping these two people from Quebec from starting a boba tea company, right? They're engaging with a culture that they might find interesting or alluring, or they might have some personal or professional contact with that group, and they want to engage with it, right? They want to engage with that culture. But when you engage with a culture without really putting in the work and the thought of like, well, what does this practice mean to this culture? What are the things that someone who's part of this culture would understand and undertake in engaging with that culture? I think that's when you start to stray into that realm of cultural misappropriation, because you don't want to be that person who opens up a bubble tea company and completely obfuscates the fact that it comes, or it's of Taiwanese origin, right? Like it's inauthentic. And while there's nothing legally stopping you from doing it, there is an amount of respect and ethical consideration that one must pay when looking to move into cultural practices that might not otherwise be of your own.
And so maybe some things, well, if we just kind of use this as an example from a best practice perspective, what are some things that this company could have done in order to still stay true to the vision of what they're hoping to accomplish, but maybe not be considered misappropriating something?
Well, I don't want to come across as prescriptive, nor do I profess to know the cultural intricacies of bubble tea. But I think that it all starts with a conversation. And if we go back to those 4 pillars of engaging with Indigenous communities, I closed the book. It starts with understanding the culture. It starts with understanding the people who exist in that culture. It starts in ensuring that, in some way the culture itself benefits from the endeavor, that the culture itself can see itself in that product or service, or whatever the case might be. It ties back into this idea of not being extractive, not taking, right? How do you build, and how do you grow, and how do you involve the community and the culture from which you are taking, but doing so in an ethical manner?
Right. And likely wanting to support, like obviously these founders loved bubble tea, otherwise they wouldn't have built the product around bubble tea. And so we don't prescribe any nefarious reasons for doing so. Like I honestly believe they love bubble tea. And so I think just thinking about, right, the cultural sensitivity aspect and being able to kind of work within that framework would allow them to kind of fulfill both obligations that, right, society has placed on them, right? Because I think it's not unreasonable to say, okay, why are we being overly sensitive in this situation, or in many situations, right? Like Canadians are often prescribed as being very, very sensitive, but in these cases, I do believe, right, that there is an obligation to ensure that you are engaging with certain rights holders, whatever that may mean, right?
Yeah, and it isn't, and it might frustrate the lawyers and the other rule, like the black letter law folks in the audience, but like there isn't like you have to do these 5 steps to be an ethical participant, right? It's a conversation, and it's understanding the community that you're trying to work with. And especially when you're dealing with a really large community, whatever the culture might be, you're not going to get the support from everybody. But that's also life. Like you just have to make sure that you really are being a good faith actor, that you're engaging with the culture, that you're bringing on partners and participants who can contribute and can help you create an authentic product that is not extractive.
Yeah, I think that's just good words to live by, for sure.
Yeah.
I realize that we're coming up on time, and maybe just one last question beyond kind of this ownership thing or examples that we were talking about, right? How should, right, audience members or people on YouTube approach subject matter thinking about cultural competence and access to traditional knowledge and cultural expression moving forward?
Well, if you need help with film and television, give me a call. I'm a good starting point. Always willing to lend a hand. Listen, like I said, it's about respect. It's about consensus-based decision making. Who are you working with? It's about participation, making sure that the community that you want to represent is actually represented and involved in the product that you're looking to make. It's about having consensus. It's about foregoing opportunities when the participants, the culture itself doesn't necessarily want to engage with a specific thing. Like it's about consideration and it's about respect. And if you approach these opportunities with the mentality, I hesitate to see how you will go afoul. So I hope that that's a good starting point, and that gives you the confidence to go out and try to engage with these concepts.
Yeah, and I think that's helpful for sure in providing just a basic framework or set of guidelines for people to think about inclusive usage. It is a struggle, like I would say, and I think these things are not necessarily, to your comment, super well defined, and it's going to be a journey for any entrepreneur who is dealing with Indigenous cultures and wanting to leverage traditional knowledge or cultural expression, right? Whether Indigenous or other cultures across Canada. Any last words as we kind of wrap up? Any top tips or tricks? Anything else that you'd like to add?
No, there's just be respectful, and try your best. That's all I can say. And be creative. Like there's always a solution. So really put on your collaborative hat and call a good lawyer too, because happy to help.
Okay. Right, and I would just add that I particularly on the Indigenous side, I think Canadians across Canada should be encouraged to be engaging with Indigenous culture and traditional knowledge, because there is so much to learn. I think the plethora of different bands and nations across Canada have amazing things to share with Canadians, and I think if we stop to listen, we'd all be better for it. And so while there are specific no-nos or things or traps to be aware of, right? I wouldn't want anyone coming out of this conversation or this webinar to think that they shouldn't be engaging in it in the first place, because it's just too hard. Because I think from a cultural mosaic perspective, Canada is a better place when we better understand the people who've been here for time immemorial.
Mm-hmm.
Okay. I just want to thank everyone for participating and joining our call today. Once again, thank you, Accelerate IP and Bradley, for hosting us. We will be back for our next webinar series, which is likely on open source software. It might not happen before the end of the year, and if it doesn't, it'll be in January. So stay tuned for that next webinar as well. I'd like to thank our guest, Mitchel Fleming, for joining me today, and I'll wish everyone a good afternoon. And thank you for participating.
Thank you, Byron.
Okay, have a great one.
Cheers, everyone.